Welcome to the Kentucky Regulatory and Appraisal Discussion. This meeting is sponsored by the Appraisal Panel Network, also known as APN, and Heartland Association of Public Insurance Adjusters, also known as HAPIA. I'm Brad Hayes, founder and CEO of the Appraisal Panel Network and president of Weather Event. I'm a damage consultant, executive general adjuster, certified appraiser and umpire, and I'm going to be the one moderating today's panel. So let's meet the panelists. Angela Andrews is CEO at Green Public Insurance Adjusting and founder of HAPIA. Angela is also a public adjuster. Eric Lamb is an attorney at Lamb & Lamb. Eric is participating in the fight against a changing landscape through litigation. Kevin Stamper started out as an independent general adjuster and is now an appraiser and certified umpire and also a licensed public adjuster. Kevin has worked as an appraiser in Kentucky for several years. And last, but certainly not least, Tom Barrett is the principal at Tobia Claim Services. Tom started his career as an independent adjuster and is now a public adjuster. Welcome, panelists, and thank you for joining us for this important topic. And Eric, I would like to start out with you, and maybe you could talk about some of the hot topics and the issues with some of the legislation that's going on, specifically around Kentucky, but maybe also nationally.
I can speak on both. We have 50 states, and each one separately regulates this. Each one separately licenses public adjusters, although I think there are one or two that do not license public adjusters. I think across the country, the insurance companies who insure casualties are recognizing that public adjusters are becoming more and more successful, roofers are becoming more and more aggressive, and the result is they're paying more and more claims. And they have responded to this by seeking legislation in the various legislatures. Kentucky is, I'd say, somewhat of a middle-of-the-road state, even though it's a red state, and red states tend to be more sympathetic, and I call them red because that's the ones I'm talking about. The Republicans are red, tend to be more sympathetic to the insurance companies, although I'm not necessarily speaking about politics. I'm just telling you what's going on. And so they proposed a statute which is in form similar to the statutes that are being proposed elsewhere. There is an attorney named Holly Soffer out of New Jersey, who I think works with the National Association. She came here to oppose it. And then when I found out about it, I got some friends of mine in the legislature to try to assist. We don't want to identify people because it could come back. The legislature adopted a statute which gave the insurance commissioner, that's appointed by the governor, and just as the federal government, the president can appoint the Secretary of State, for example, or the Department of the Attorney General. And we don't know where the power will be with the insurance commissioner. We're hoping it'll be with us because we think both the governor and the legislature will have some sympathy for us. The major provision is they limited the fee to 10% on catastrophic claims and 15% otherwise. Actually, we increased it. It was going to be 10% on all. And yet it's unclear whether you can charge an hourly, such as in an appraisal or on a consultation. And I give you a strong legal argument that since they didn't say you couldn't, you could. Another thing that is unclear is whether you can charge 20 claims partially over, and you can charge 25% of what additional money you get, limited by 15% of the entire claim. At one point, Tom Barrett, who's one of the panelists, got a contract approved that said that, but then they rescinded it. And then a third change is they wish to control the contracts and require approval. And there are provisions that an attorney who knows what they are doing would put into a contract, such as a lien for the adjuster, which I think is enforceable. You may have that lien even if it's not in the contract. And other provisions, such as what county you're going to sue in, that's called venue. So there are some things that are up in the air right now. And this is, and also I think they're trying to get insurance policies which limit cosmetic matching, which is only part of the matching issue, to a certain number of years. So at this point, I think I've outlined some of the problems.
Now, Eric, you're an attorney in your office is in Kentucky?
That's correct, in Louisville, Kentucky.
In Louisville, Kentucky. Okay.
All right.
Now, Angela, you are a public adjuster. You're founder of Happia. You also operate in Kentucky as well, right? You service Kentucky as a public adjuster?
We do. Not our primary state, but we do service Kentucky, yes.
Okay. And what Eric is talking about, how has that affected your business, or what has your experience been in Kentucky?
So most of our experience in Kentucky started with the 2021 overnight tornadoes. Everyone remembers that catastrophe. And Sean and I, my husband Sean, we were in the state for about 4 months resident to help service the residents hit most hard by that event. And we continue to write new contracts for, I guess, referrals that are specific that come from contractors in the state. We don't solicit in Kentucky new business per se. So we have fewer claims coming out of Kentucky than we used to. So I just want to make that clear. But pre-regulatory change in 2023, June 2023, we had the contract that we used in Kentucky, first of all, didn't require pre-approval by the state Department of Insurance. And the contract that we used is similar to the contract that we used in other states that had already been written and scrutinized by our attorney. And the only additional caveat to the contract at that time was we had a specific expense disclaimer form and notice to the client saying, you know, we have no relationships that are financial fiduciary relationships, anyone that we might recommend. So that was our provision in the state at the time. It's a pretty simple contract, very easy to read. And I make this point because when we were in Kentucky for the tornadoes, a lot of the residents, depending on where they lived, either they didn't have internet access, or if they did have internet access, they maybe weren't tech savvy, right? So older people, people who are used to doing things on a handshake because they know their neighbors, you know, they live there for a long time. They know the people who there. So we had to do wet signatures for almost all of our contracts. So we tend to, as a business, sign everything DocuSign, electronically processing. But for Kentucky, we had to do wet signatures. And since the changes, our contract now looks like you are buying a home, honestly. There's so many provisions. It's scary for a homeowner, especially. Not so much a business owner, but a homeowner looks at that and they think they're signing away their firstborn child. So it takes a lot more conversation. And this was the contract that we had to get that we got through the Department of Insurance. So our attorney worked directly with the Department of Insurance for about 3 months, trying to get a revision to our original contract approved. And we already charge rates that are within the proposed Model Act change at the time that we were submitting this, and then it became law. So the rate itself was never an issue for us. It didn't change the way we did business as far as our rates are concerned. But the language in the contract got so specific and so restrictive. And if this happens, then this is the outcome, that we lost several clients in the process. And the clients that, so after we got approved, we lost several contracts in the process of signing the contract. And then during the waiting period, that 3-month period, we also had to come up with alternative means to service people because we didn't have an approved contract.
Okay. So the contract changes, when did that take place? Was it 2023, 2022?
Yeah, so we got an email, I believe it was June 28th, 2023, saying, starting tomorrow, you guys have to have an approved contract or you can't sign new business. You can continue to service the clients that you already have under your existing contracts, but you have to change things effective tomorrow. I think that might be the correct date. Tom, I think you were on the front lines. You can correct me if I'm wrong on that.
Yeah,
Okay.
it was right around June, July, and then come September of last year, also they went back again and told us that our contracts weren't approved because of what Eric had mentioned earlier, what I call a 25-10 contract, 25% of new money capped at a total of 10% of the total claim. But yes, that's that date, that time frame is accurate.
Tom, since you kind of jumped in here, you started out as an independent adjuster, is that correct?
Yes, sir.
And now you're a public adjuster.
October of 2019, I switched my license to public adjuster. So I've been on this side of it for going on 4 years.
So you've probably seen a lot of changes in this industry as well, besides the contracts. So how has your business been affected by these new contracts and some of the other issues that Eric brought out?
I mean, the biggest change is, like Angela was talking about, just a lot of more hoops, more hurdles. I got a $50,000, surety bond that's required by the state, but I also carry E&O and general liability. It's, to me personally, it's hurdles, nothing insurmountable. The biggest thing for me is the fee cap. I think that's unnecessary, and yeah, it does affect me a little bit, but it's more anti-consumer than anything. And I think that's what the focus needs to be on. That's the important part here. Yes, it just means I'm just not going to take smaller claims. That's all it means.
Could you drill down a little bit about the fee caps and why it would affect your choice of taking on a client, and then how this affects the client?
I've got some notes here. According to the 2010 Insurance Information Fact Book published by the Insurance Information Institute, 87% of all claims nationwide are valued between $2,494 and $7,163. That was updated in 2017 or 2021. And now they're saying that the average is $13,687. Practical sense, what that means is that the insurance company is going to pay the undisputed amount of the claim. Usually it's a pretty good chunk of it. And for 3 to 6 months after I get signed for additional money, I'm going to work in a catastrophe situation for 10% of an additional $4,000, which I just can't do. It's practical. It's a practical reasons I can't do it. I get enough residential with friends and family. So that's the biggest thing. It's just going to affect smaller claims, and these people are going to be left to fend for themselves or go the appraisal route, as we'll probably discuss in the future, or pay a premium to an attorney.
So Kevin, I need you to jump in here for a minute. You are an independent adjuster, appraiser, and a certified umpire. Is that correct?
No, I'm a former independent adjuster.
Okay.
I was an adjuster from 2011 to just this past June when I switched my license over to a public adjuster.
Oh, you okay?
So I do appraisals. I've been doing appraisal and umpire work for about 5 years now. Also have, during a transition, I also have my contracting business as well. So, but however, people are like, well, you can't be a PA and a contractor. You can in Kentucky and several states. It's just certain states like Kentucky, it's illegal to be a PA on your own file as a contractor. And I see that, even if it were legal, I wouldn't do it anyhow. I like to keep nice, crisp, clear boundaries of unbiased. So.
Sure. Okay. How has this affected your business, either as a contractor or as a public adjuster?
Well, as a PA, I'm just now growing my business, but it's, they have put some hurdles out there for us, pretty sizable hurdles for us to get over. And especially for PAs coming into the business. I'm in receipt of a letter today from the DOI, a complaint on a contract that I signed before they required us to have approved contracts. So that contract, of course, is not in compliance with the regulations now. But Now they're sending out, no, I've got this complaint here that's erroneous in my eyes, in my opinion. So now I've got to take time out of my day and send back all the information to show them that no, that contract was in compliance at the time of signature. It's not in compliance now if it were a new contract. But no, now I have to go back and unravel a ball of yarn and take time out of my day to bring them up to speed on their regulations that they set forth on contracts. So that concerns me. Do they really understand what's going on? Because when we're all trying to get these contracts approved, like Tom said, they approved us, and then come September on a Friday at 4:30, we all receive an email, hey, your contracts are not approved. So
Yeah.
and they were approving contracts for one individual where they would not approve a contract for this individual, and it's the same contract written, very, very, very similar.
So you do not in other words, as a contractor, you would not also be a public adjuster on the same claim. Is that correct?
Correct.
So you don't really have an issue, or of what is your PA contract? How does that affect your contractor's contract? You don't mix the two.
No, I don't mix the two.
Okay.
I just hope that, my contracting business doesn't need a PA, because then I'm not doing something right as the contractor. Of course, as a contractor, I'm not speaking policy, but I just know with my former insurance experience how to get things properly written, scoped, and spoken correctly without even having to use insurance policy.
Right.
Actually, not
go ahead.
to cut you off, Brad, but I think that's a very unique perspective of all the PAs on this panel. We've all been independent insurance adjusters. I've been in management roles on the insurance side prior to becoming a public adjuster. And so all three of us, we have our own experiences, and we're not anti-insurance company. So, sometimes you get a public adjuster in a forum or having a conversation, and they've got, one perspective. And I've seen from both sides, I've seen, some good things happen and some not so good things happen. And so when we give our feedback, it's based on a more balanced exposure than maybe the average public adjuster has. So I think that's important to note.
Sure.
Right. Yeah, exactly. It helps. It really would help PAs to know the policy very well, and also to know the contracting side as well. Also, that's going to help the consumer out in the long run.
Yeah.
This is where I might get involved. First of all, I'm the attorney for a number of public adjusters in Kentucky, and we're right now kind of in a holding action, but it's highly questionable they can do many of the things they're doing. Certainly, they cannot regulate a contract or declare it void if it was entered into before that statute took effect. That's the first I've heard of that, Kevin. And many of their model contract, I think, is highly questionable. But our legislature just opened. The insurance side was very well organized going into the last legislature. And we're kind of in a holding action right now. We'll try to figure out what's going on. But the things that are happening will not necessarily be effective. There is in Kentucky and in many states, there's an Unfair Claims Settlement Practices Act, and it is conducive to legislation in many situations. And if an appraiser can be paid by the hour, that can be an effective way of dealing with this to an extent. Although I think every time we try to do something, the insurance agency, the insurance industry may turn around and try to counterpunch. But it's not necessarily a done deal that all these things will happen.
I want to ask, a question, I guess, to the panel, and anybody can jump in here. There's a lot of thinking that says the appraisers and the umpire must be impartial and disinterested. And I think that cuts both ways for both sides of the policy, right? For either the carrier appraiser or the policyholder appraiser. And do you see, as public adjusters, which three of you are, do you see that more public adjusters are going to switch over to doing appraisals in kind of light of what's happening with some of these new laws? And Tom, let's start with you. How do you feel about public adjusting, kind of taking on more appraisal business? And then what does your appraisal fee look like? Would it be a flat fee? Would it be by the hour? Probably not so much a percentage, but go ahead and speak on that.
Well, before I always I'll review the claim documentation that was generated in the process and make a determination as to whether or not the file is properly documented on the policyholder's side. And if it isn't, they're ripe for being, in my opinion, public adjusting. If they have a good file or it's very simple, I may send it to appraisal. The one good thing we have in Kentucky, and Eric, you correct me if I'm wrong, but I do believe that causation is appraisable in Kentucky. So that's a feather in our cap in this state. I think that the problem with appraisal I see is I think it's being overused and it's not being properly done. If you don't have a documented file, the appraiser is going to have to document. The homeowner is not going to do it. And typically the roofer that may have brought up the appraisal notion hasn't done it either. So you're doing, you have to have it properly documented. And across the board, carrier and policyholder side, I do not see that occurring anymore. As far as my fee, I charge an hourly, I charge a base, a minimum, and I have a contract. I contract with the homeowner, and really the reason I did a contract over and above just to protect my fee interest was to make sure that the homeowner understood the good and the bad of the appraisal, because it's not all good. The appraisal award is a binding document. You can't supplement it. Your only option after going to appraisal and getting award is litigation. And I find that a lot of homeowners don't know that. So, there's many layers here, but I want to do good, but you just can't help everybody. And some people have already stepped in it, and it's not fixable. But as far as how I handle it is, you got to review, you got to know what you're doing. One good thing about working for the insurance companies for 28 years is I know how to document a file. I know how to read the policy. I know how the policy functions. And I
want to address a point that Tom made. First of all, it's national precedent. I had two cases where we triggered the appraisal clause recently. The insurance company tried to oppose it on the grounds that these are issues of scope, meaning causation, and you can't do that, both in Jefferson County, Kentucky, and I made a motion to compel appraisal in both those cases and was successful. And their research, and they were prominent attorneys, they could not find cases across the country that supported their position at all. Second of all, and I've not heard that you can't supplement it, I think you can get a declaratory judgment that would allow you to supplement after they, for example, do a roof and they find that there's more damage. So that is not necessarily so, Tom. But then what Tom said, you have to be prepared. I recently did an appraisal with Tom. I was in 23 or 22. I can't remember, Tom, against a prominent insurance company. Roof on condominiums was a large six-figure claim. And he was successful because of his knowledge of how to document the file. And he had a long, detailed appraisal package that discussed the law some, and he obtained a good umpire, which is something I think I can consistently obtain an appraisal in Jefferson County, Kentucky, maybe in other counties.
So, Eric, I have a question for you. In Kentucky, what is appraisable? Is the scope appraisable? Is causation appraisable? Clearly estimating and coming up with a dollar value is appraisable. Are all those three things appraisable in Kentucky?
Yes. And I'm going to cite a couple of cases because attorneys may hear this. The best cases that the firms could come up with against us, just like you have Brown v. Board of Education, Roe v. Wade and Hobbs, you have cases in insurance. They came up with Mattingly v. State Auto Property. That's 2023 Westlaw 32004, a motorist mutual. That's MUT period INS period CO period V post. That's another 2005 Westlaw 2674987 case. That's the best they could come up with. And neither of them said that causation cannot be appraised. And I was able to show in court that was happening all over the place that umpires were deciding causation. And I was able to tell the judges, all of the other retired judges do appraisals here, and also some others, case after case after case, federal court cases, state court cases, where that was decided in appraisal, because as you know, there have been many appraisals. So they could not beat me on that. They didn't say much in court. One attorney, the State Farm attorney, kept saying that, no, this is not appraisable. And the judge, a smart judge, said, no, this sounds like the dispute here is not over causation, it's over the amount. Because they often accept the claim in part in the beginning. Because if they don't, they can be sued for extra contractual remedies. So I think you got a very strong argument in favor of appraisal. However, you have to get a good umpire. You have to get a judge who will appoint a good umpire, and you have to have a public adjuster who's on his toes like Tom was in this one appraisal we did.
So one more question for you, Eric, and then I'm going to pose a question to Kevin and Angela. Who in Kentucky can be an appraiser?
Anybody.
So there's no licensing required. There's no education required. Anybody can be an appraiser. If they decide today I want to be an appraiser, they can be an appraiser.
All the insurance contract says you have to know where the appraisal clause is. And if you can't find it, put it up on your computer and search for the word appraisal. It talks about, and I got one of these clauses here somewhere, a disinterested appraiser. This idea that there's a new case that said that back in the 19th century, we're talking about the 1800s, they came up with this idea that both sides would name a competent disinterested appraiser. They better be competent. That's not going to work. And the two disinterested appraisers would then appoint a disinterested umpire. And that sounds like, and I've been known to vote for that. That's just like an extreme left-wing idealistic concept. That's not the way the real world works. There's a case somewhere that says the modern trend is against that. But but it doesn't say anything else. The appraisal clause is only a paragraph. It
Right.
doesn't prohibit much.
So we all know that, you have to be competent, right, to be an umpire, and you would think an appraiser as well. And I think that Tom and Angela and Kevin, you have years of experience in this industry, and you started out as adjusters. So you have a good handle on both sides now because you're also public adjusters, right? As we know, there are contractors that want to be appraisers that they don't know the policy, they don't understand really what's going on the policy side. We also understand that there are brand new insurance adjusters, right, that also become appraisers. So to make it absolutely fair, we know that there are probably some weaknesses on both sides. We understand that. So Angela and Kevin, what is your thoughts on the education piece, on raising the bar, raising the level of education for those that want to become appraisers? And do you feel they should be licensed in Kentucky?
So if I can start, and I'll punt to you, Kevin, specifically on the contractor piece, because I know that you're extremely well versed there. I don't know that there should be a license for appraisers. I don't think it's gotten to that point yet, just like I don't think there should be specific regulation for appraisers. I think that the industry itself, the market tends to right itself when things are getting too extreme on either side. Tends to, not guaranteed. But I don't know, Brad, if you know that I have an IA group that I started years back, I think in 2016. And I've got almost 10,000 independent adjusters that I help mentor, help coach, most at no charge. I don't do individual time. at no charge, but for the most part, I offer my time and my services to them for any questions that they have. Again, I'm not anti-insurance company, so I don't think that there's any kind of issue there with helping IAs, because I don't sell the PA approach necessarily. But I will tell you that especially during COVID, there was a big rush of insurance adjusting firms that supply staffing to insurance companies looking for appraisers, even in my beginners group. I had people approaching me all the time asking me about the opportunity to be an appraiser. Even recently, I was at a roofing company and I had someone who serves in an admin capacity who's very unfamiliar with what an insurance policy is, doesn't have any construction background. It's one of the, you know how you'll have like, I don't want to say like receptionist because that's not her role. She had a lot of experience helping facilitate with client interaction and with all the roofing sales guys, but not someone that you would automatically think, okay, this person should be an appraiser. And this person knows that I do training, and she approached me about training so that she can become an appraiser because she heard what fees we charge on our appraisal services, and she wanted that opportunity because she thought it was a better opportunity than what she was doing. So I do think that there are, because there are no licenses and there are no regulations, there's possibly a certain percentage of people who have zero experience and maybe should not be involved in appraisal capacity marketing themselves. I do not know that these people are successful getting work. So I don't think it's too much of an issue, too much of a problem. The people that I know who asked me about how to become an appraiser, if they were really serious, they usually followed up and did some training. So they went to the WIN Network or IAUA, which is where I'm certified. I'm a certified appraiser and umpire. There's the Plan Network, John Robeson, he offers that training. So people who I know of who are interested and we give them this feedback, they've gone and gotten additional training. They've started out kind of from the ground up. They usually have a background, maybe not 28 years, Tom is extremely experienced. Tom is probably one of the better people that I would recommend in our, not even just in the Midwest, but one of the people I would recommend. I've also worked with Kevin, and so Kevin knows that. When we first started out, he wasn't a public adjuster yet, and we used him for several of our commercial appraisals. So these two guys, I can't say enough good things about their experience. We've kind of relied on their support for several things. But I will say that there might be trending as independent adjusters find difficulty either finding work or maintaining consistent work. You may find them moving into appraisal or public adjusting work in their markets, but I don't think that anyone, I mean, this is a business. This is not for the weak, especially with the fee caps coming in pretty much across the country now. When you're starting off, you don't get $1 million claims starting off. No one hands you that. So you have to work to get to those levels. And if you don't have the experience, if you don't know how to properly document a file, if you don't know what you're doing, you're not going to have much success. And then to your question about contractors, which I'm going to push over to Kevin, we talk to contractors all the time. They come to us for advice about their claims. And some people have approached us about either doing appraisal work or becoming a licensed public adjuster for certain reasons. Sometimes they want to control the flow of money, things like that. That's more difficult when they're the roofer on a claim. But the statistics are there's 1 in 20 households that file a claim that are insured households. I think it's 1 in 35, that are claims related to wind or hail. In the Midwest, that's our bread and butter. That number doubles almost when you're looking at water damage claims, 1 in 60. And this is just based on various data that has been solicited and published by the Insurance Information Institute. So this is 2017 to 2021 data, the most recent data I have access to. So when you have that many claims that are being filed and that many contractors involved, the documentation, how the file is set up, all of that's going to be really important to the success rate in appraisal. And this is where I think, Kevin, if you want to speak to that, if you want to pick that up.
Yeah,
I need to make a quick point. We do not want the legislature with the insurance companies involved to license appraisers. For example, in Kentucky, in workers' comp, they licensed or they set a requirements for who could decide a hearing loss case. There was only one person that qualified, and he was for the insurance company. And I don't want contractors doing it because they don't have a clue what they're doing. I had one refer me a case where he proposed a $40,000 roof repair, which should have cost $20,000, and he's not going to win that with the umpire. We need appraisers like the people we have here.
Now, speaking to licensing for appraisal, I believe there should be a set of competency. When I worked on the IA side, I was a team lead for a while. I managed 5 states: Ohio, Kentucky, Indiana, West Virginia, and Georgia. And, the IA firms, if you have a license, they'll hire you. I remember some of the adjusters coming to the storms, and they didn't have a ladder. They didn't know, they didn't have exactly loaded on their computer. And, there's a lot more to being an appraiser than just going out and say, hey, I'm an appraiser and we're going to split the baby. I got my certification through John Robinson's class in IAUA. I was certified with both of those outfits there. Great outfits. John goes really in depth on his training. And for some of the IA firms now that we're going up against, not against, but opposing appraisers that's coming in, they don't know how to take their adjuster hat off and be an appraiser. I have several IAs that I mentor on the appraisal side. I did a handful of appraisals on the carrier side for a while. I wanted to kind of take a peek in the room and see how that side worked. And, they're always talking about collusion and all that. But the ones that I mentor, they're always telling me, hey, Stamper, you need to take your contractor hat off or your PA hat off. I'm like, listen, I'm very versed at taking all my hats off and being just very unbiased. And the damage is the damage, and that's what we're going to write for what we can show in the photos and document your file correctly. And you have to take the carrier guidelines and toss them out and go by today's construction methodologies. And what it's going to take to get that piece of property back to a pre-loss condition. So I think there needs to be some sort, maybe not licensing, but a requirement of so many hours of some kind of testing. It doesn't have to be a license. Maybe it's a requirement. I don't know. But there's some appraisers out there, they're doing their client, either the carrier or the policyholder, they're not doing them any good. They're doing more harm than good. I was like, when you get into a position where I had an appraisal up in Ohio, and it was for a wind hail claim. Me and the opposing appraiser were on the roof. Roof was solid. Brick home all the way around, solid. So we didn't feel the need to take a look in the attic. When the contractor gets the roof torn off, it had 1x8 decking, which now 1x8 decking shrinks quite a bit. It had, in some places, 3/8 gaps, and they were going to have to oversheet the decking to take care of the gaps. Well, that wasn't part of the appraisal. I was successful in getting that entered as a supplement and paid for, but I had to invoke the umpire at that point to get the insurance carrier adjuster to say, no, appraisal's not final. We can take care of this unforeseen issue and take care of that. We agreed to replace the roof, but the unforeseen issue, we were able to take care of that. Any other appraiser that didn't have the experience of a prior adjuster, I would say would have an issue thinking through that thought process. So,
and that's I will also say, Kevin, that's also to Eric's point about Tom and us being, you know, having more versatility. If you've only got one side of the story before you start specializing in something, you are going to potentially be doing a disservice, whether it's on the IA side, on the carrier side, or on the PA side. And a good
absolutely
public
agree.
adjuster is going to check that attic before they even submit anything to the carrier. They want to make sure they have the full scope documented in dispute before they demand appraisal. So,
Right.
yep.
So I was able to get my thought process and the whole panel to agree, hey, yeah, let's review this and see if we can get this taken care of for the policyholder. So it had to go up a level in management at the carrier for them to say, you know what? That wasn't part of the appraisal, but it's part of the claim. So they were able to look at that and eyeball and say, yeah, you know what? Let's open up the coverage for it to get it taken care of.
Sure.
So
I'm also certified with IAUA and Plan and Wind, and they're three very good courses. And I kind of want to throw something out here to everybody. We all know that each carrier has their own best practices, and they're not all the same. There's some are quite different. When you meet with a carrier appraiser who started out as an adjuster, maybe is not that experienced in appraisal, and they want to refer back to, well, this carrier doesn't pay for that, this carrier doesn't pay for this. How do you handle that? Best practices of the carrier should never enter into appraisal. So what, Tom, let's start with you. How would you handle a situation like that?
Well, you do the best you can, but some people you just can't talk to. I mean, I hate to admit it, even when I switched my license, I realized how indoctrinated I was about the internal claims processes at these carriers, and I worked for a lot of them as an independent.
Sure.
There's not much you can do in that case other than go to umpire. And as Eric said earlier, hopefully, the most important part of the appraisal process is selection of the umpire, in my opinion.
Right.
I don't know if there's a silver bullet for that
Sure.
situation.
How about you, Angela? How do you handle something like that?
So I'm very rarely on a roof these days. But you guys all know Sean, and Sean's our resident billy goat, so he's always on roofs. Just yesterday he settled a claim for us in appraisal, and this is a roofing loss up in Monroe Falls. The carrier paid $773 to the homeowner. This is a retired couple, and it ended up in. So I don't want to mention the carrier, but the carrier's appraiser was very well aligned with the carrier adjuster. So it ended up having to go to umpire. But the contractor's estimate, our estimate, was roughly 52,000, and it settled for just over 50,000. So 96% of the original demand is what got settled, not because of the footwork and talking, but because that was the appropriate resolution for the claim. And so I can tell you what Sean does on our cases. I've not seen one case, and I hope no one proves me wrong after this, but I've not seen one case where Sean was on the roof with whether it's the adjuster, whether it's the engineer, appraiser, where he couldn't present his perspective in such a way that allows the other person to just listen and consider. And sometimes that's part of the issue. There's some PAs who have a very, they come in like, oh, I'm gonna gonna sell this case. I'm gonna take you guys to the cleaners. The insurance company is the devil, and da da da. And they're very aggressive with where they're at. I don't think there's anyone here on our panel, but the way that we approach claims is we try to approach them based on the facts. So we pre-inspect, and then we go back and do a mutual, and we point out the facts that we were able to research and show proof of our position. I've seen, Sean's not allowed to talk to me about cases that are in appraisal, right? But I've seen him go back out maybe 2 or 3 times to meet with someone. And then once the claim is resolved in settlement, it was because either the opposing appraiser gave a little bit on their end and it came to a successful resolution, or if they gave a little bit and it didn't get where it needed to go, it was fully documented so that when it went to umpire, our position was well represented, and it settles more likely than not very close to where it needs to be for the work in order to get done, for the work to be done. So it may not have as much, profit built in for the roofer who wants to do the job, but it's enough money to make sure the job gets done, whether they choose that same contractor or not to do the work.
Mhm. Kevin, how about you?
Well, the issue is that there's both sides to it, where the opposing appraiser will say, I'm going back to taking your hats off and on and off as an adjuster and an appraiser. I'll have them say, well, we don't pay for this, we don't pay for that. And you have to routinely bring that up and go back and explain this is appraisal. It's not policy. And if you're going to keep bringing up policy, that just, you write your position, I'll write my position. We'll go on to umpire. I'm very non-confrontational on all my files. I'm not going to jump out and get out of the car hollering, screaming. I've seen heard guys doing that. I've heard contractors showing up, getting in the carrier appraiser's face, and she had to call the police, and it was a mess. It gives us all a bad name, and there's no need to be confrontational. As long as you have the facts right, you know what you're doing, you can write a good position and present them in a professional manner. There's no reason why you can't get to a good settlement.
That's right. That's right.
But I want to take that. There are some reasons you can't get to a good settlement, because you have to go back to make sure you know your umpire's position. And I would say you need to sit down and revisit with your umpire at least once a year. Because I just had one go completely sideways on me. And it really put the policyholder in a bad spot.
Yeah.
So I would highly suggest getting to know your umpires and keeping in contact with them and seeing where they are in their mindset of their thought process. Because, the arena's really changing. The IA firms are out there hiring, doing the appraisal work. There's a friend of mine, he owns a very large appraisal company, and that's all they do for the carrier is appraisals. And he hires mostly IAs because he knows, number one, they know policy. Most of them know Xactimate, and they know how the processes and procedures should go. Now, the problem is, and I've spoke with him, his biggest issue is getting the individuals to change their position from being an adjuster to being an appraiser. That's the biggest issue he sees out there on that side. You know, just because he represents carrier side doesn't mean he and I are not friends. We're pretty good friends. We've been friends for a long time. He was up in management in the IA firms I worked for. I reported to him directly.
Right.
So that's the big issue out there, is getting people to be unbiased.
You're right.
Can I add a quick statement? What Kevin brings up about knowing exactment. So, you know, exactment and stability are two of the more prevalent ways that people write the estimate and the scope. And that's really, really important to the analysis of the case. I do know some appraisers choose to work outside of either one of those software templates. I don't know the systems, best way to describe them. But for the most part, your appraiser and your umpire should be writing their own estimate. And one of the trends that I have seen, that I hear most complaint about, is when the opposing appraiser just mimics the insurance company estimate and they don't write the estimate on their own, whether it's because they're too busy or they're just so straight aligned with the carrier position. I couldn't speak to why they do it that way. But yeah, that's become a really big issue, and probably for another session, but
Yeah. Yeah. A lot of these topics can go on and on.
Oh,
We
yeah.
could have several meetings about these topics, but Tom or Kevin, I like what you said. You know, when I start out, when I meet the appraiser for the first time, I kind of review why we're there, right? We're there,
Right.
depending on the state that we're in, we're there to look at the causation, the scope, and the value. We're not here to look at the policy. We're not here to look at best practices of the carrier. This is why we are here, right? And best practices has no place in the appraisal award unless it's industry best practices, how we're going to put this property back together. And
Right.
my thought with the other appraiser is always this: if it's not covered in the policy, that's going to get sorted out after the award, right?
Exactly.
But
Was
we are not here to determine the policy or what's covered or what's not. What is it going to take to put this property back together and let the policy speak for itself? And
Yeah.
and that seems to help a little bit too. So I think it's just having that conversation with the other appraiser of why we're here. We're not here to adjust this claim. We're here to
No.
appraise the claim. There's a big difference.
And a lot
Yeah,
of
but
times
the,
I explain to them, you take the settlement, you know, the award, and this is what it is. And then the insurance company comes and takes a policy and lays over it and see what's covered. You know,
Right.
they're the ones making the coverage determinations.
That's right.
This is what it's going to take to get the policy or the home back to pre-loss. Then you take the policy, lay over it, and what's covered is covered.
That's right.
but what is covered is often more than some recognize. I'm just speaking as a lawyer. Almost all the policies have the same language. It's called an ISO provision. And what it talks about, there's 4 paragraphs to determine replacement cost reimbursement value if you've got replacement cost in the deck sheet. And a term on one of them is, quote, the loss or of the damaged part of the property. And here is the big key, and public adjusters and appraisers need to know this. Where you don't have a matching roof, the entire property is damaged because the value of that property has declined. And that is why, and there's case law on that. And some people say, well, Kentucky's a matching state. There is no case in Kentucky on matching except for mine, and mine quoted a bunch of other cases, which I could cite maybe in another seminar, but the policy always supports the correct thing, I think. And there are cases that say if there's an ambiguity in the policy and they deliberately write an ambiguous policy, that's resolved for the insured. Then the other part is, what is the actual cash value? Xactimate, if you punch a button, will give you a number. But a big key to the actual cash value, I've found in some of these big claims where I've represented people who develop shopping centers, for example, or build large buildings. They are experts on what the depreciated value, that's what the ACV is, and they'll testify that the actual cash value has decreased because of this damage. I can't sell it for as much money because it's uninsurable. It's got leaks in it. Nobody wants to live in it. So the concepts of replacement cost value and actual cash value in the policy are much more liberal than some recognize.
Can I ask you, Eric, how does diminution of value compare to the decreased value that you just spoke to as far as legal terminology when it comes to evaluating the loss?
It's the same thing, and it's simple to explain. If I go out and I buy a Subaru, which is what I like, when I drive it off the lot, it was worth about $30,000, the model I bought. But after it decreases. So a year later, 2 years later, the depreciated value, and you've got the books on that, is less. It's simply the value after. Actual cash value, diminution of value, and depreciated value are the same thing. But if you're talking about a property, if you can also get a real estate expert to say, this is not worth as much. If I charge rent on this building, which had been damaged, I could have charged $1,200 a month before this loss. But now, with the water loss and the entire inside of the property, hey, there's no kitchen, there's no flooring, I couldn't rent it for $400. That is the testimony you get, is the real estate or a rental expert. So there are ways to present this in appraisal. That's the way Tom did it, I think, in the one package. I might work with Kevin on some, and you just get a common sense estimate of that value after the loss. After the loss. Now, if it's only a small part of the roof, it may not reduce it much, but I've got a lady that says, I can't stay living here. It's an embarrassment to me that I have a roof that looks like this. So you can construct an argument. And I want to say one more thing. I'm representing my client. The public adjuster represents his or her insured. And I just want to have a competent public adjuster. I want, in the free enterprise system, for people to learn how to pick a competent adjuster. And if the other side's incompetent, that's good. Then we'll just take them on one-on-one before the umpire, and we will win if it's a fair umpire.
I just want to clarify, because this might be really important to people who are listening to this. Are you saying that you can use the diminution in value because, you know, in most states, diminution in value is not factored in, at least overtly, by the carrier when they're developing their settlement costs, right? But are you saying the diminution in value, if it's demonstrated and applied for the actual cash value or the material depreciation, whichever one you're trying to use it for, that can be appraised? That can be used in appraisal, the diminution of value?
I think there are cases in most states that you have to look at the value before and after a loss, whether it's a car, whether it's a hailstorm, or whether it's a water loss. And there are a lot of attorneys that don't understand, because I have some, you know, I've had cases in Kentucky, and I usually hire a local attorney in the case if I'm out in the state facing a local attorney. On the other side, it's like playing Kentucky in Rupp Arena, but I always get one with me that I control it. You can explain it that way. A lot of the attorneys don't know what depreciated value is. You just get an expert to testify. ACV, if you push the Exactimate button, gives you a very high ACV. And I just got a case. But the actual cash value is just what it is worth. ACV, actual cash value, and what it was worth before, and now what is it worth after? That's what that word means. That is what that word means. It's not defined in the insurance policy because they don't want to tell you anything. But if you look, but that is where it is in all kinds of cases across the country, actual cash value. And I've got a case out of New York that I use. The World Trade Center, which is the most famous casualty claim in the history of this country, was appraised by a panel, and the panel had a whole lot of public adjusters on it. And in one of the cases that went to court, the World Trade Center explosion, and I quote it, and I gave it to Tom for that appraisal package, when you purchase replacement cost value, you can profit on a loss because you paid premiums to replace. So 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 the World Trade Center court, trying as hard as they could, and our nation's greatest casualty, has got a quote you can use and you can put in your appraisal package.
I think, well, in fact, I know so that with Xactimate, and Angela, you might want to speak on this too, but line item by line item, you can adjust the depreciation to control the ACV. So it's not just one blanket ACV or depreciation on the whole claim.
Right, yeah. So I recently got certified as a pricing consultant through Verisk for Xactimate. And through that certification, we learned how to adjust all kinds of elements in the software, including elements of the labor burden, anything that so most adjusters, most IAs are taught how to make adjustments to the material component pricing, right? So that might be how far you know in diving behind the scenes, but we learned how you can change the pricing on lots of different elements, not just factoring a percentage across the claim value. And we also learned that some of the pricing is interdependent. So if you change the value on one item, if you have 10 supporting items that are used for that repair, then Xactimate's pricing will automatically change incrementally the amount of money that's allowed for the supporting materials as well. So there's lots of different things if you're using Xactimate that you can use to demonstrate the specifics of that one loss. You shouldn't just take what's presented to you when you put in a line item. If you know that there's if they already have a contractor and this contractor has a workers' comp insurance obligation that's higher than the average for the city or the state or whatever, you can put that information in there. You can change those numbers.
That sounds like that's another panel topic. A
Another
topic for a panel we
day.
should have. But I tell you what, I like to keep these within an hour because I think most people will watch it for an hour and then they drift off, right? So kind of in wrapping this up, Tom, is there anything you would like to say in closing? And then we'll go on to Angela and Kevin and Eric.
Yeah, I appreciate being on the panel. The only thing I could really close with being, if you're a new PA, the best advice I was given is this: you're not going to be successful because of the claims you take. You're going to be successful because of the claims you don't take. And that's more true now than it was in 2019.
That's
That
really,
should
that's good.
keep you in good stead.
That's good. Angela, what would you like to say? Anything?
That was very deep, Tom, and you know, we didn't actually practice that. We didn't know to put it in that language when we first started, but we are more selective, even more so now than we were day one when we started our business. Yes, I want to say in closing that we talked about education quite a bit. We touched on it at least, and we recently started an association at the end of 2023 in October. It's HAPIA is the acronym, but it's Heartland Association of Public Insurance Adjusters. So this will service the 12 Midwestern states. It's one of the happiest that, you know, people know about across the country. And our goal, we'll have to do quite a bit of, you know, fundraising and developing of programs, but our goal is to be able to provide mentorship and training opportunities to both new public adjusters, contractors who might be looking to increase their knowledge across the board, maybe transition into other roles, even appraisers if they want to come and learn some things on the insurance side if they've been in one hat or the other. So it's not a plug. I'm not plugging HAPIA, but I'm saying in closing, look for opportunities to educate yourself and align yourself with other professionals, find a network so that you are continuing to grow in your skill set, because no one is going to start working in appraisal on day one and be as good as they need to be just because it's a new area of specialization. There's negotiation tactics and techniques you don't know on day one. In 5 years, you're going to be a different kind of appraiser, and you'll look back at day one version of you and just laugh. So I would say continue to find encouragement and find support, and continue to support other organizations that are helping you with that.
Very nice. Kevin, how about you?
Well, you know, being new on the PA side, as a licensed PA, but I had been going to a lot of the, Jack Hanks and David Skipton's first PA meeting out there in Scottsdale at Dave Skipton's office. So I've been into the PA training for several years prior to making the official switch. And what I see now, what I started to see then is really evolved into a lot of the PAs coming together, working together, and trying to, just like the insurance companies, they work together on their issues and topics. But I like to see us all start to work together more than against each other. There's plenty of claims out there, just like, I do appraisals for a lot of other contractors right here in my area. One's within a mile from me. And people's like, how do you do that? It's like, I can't roof every roof in Kentucky or Ohio. I can't handle all the claims, nor do I want to handle all the claims. What I see, you just have to have an open mind. We all need to work together with each other for a common goal.
That's right. Very good. Eric, one last comment from you. Anything that you'd like to close with?
Yes. First of all, it's not necessarily so in court or in life that it's best to go last. If you go first, you can often preempt the other side. The second point is I was taught long ago that the most important thing in any case is the merits. Who's right and who's wrong. You don't come in with an estimate which is beefed up to a $40,000 roof when it should be $20,000.
Right.
You don't put in a projection for porta cans when you're not going to need porta cans. You come in with something that's truthful, and you'll get the respect of the umpire. The merits is what this is about, and that's why all these meetings and seminars could be very important in teaching each other and learning from each other.
Very good. Well, panelists, thank you very much for your time. Appreciate it, and we'll probably get together again soon.
Thank you, Brad.
Thank you.
Brad.
Thank
You're
you.
welcome.